listen to the rules and procedures that will follow for tonight's meeting.
Good evening, and welcome to tonight's meeting of the Town of Babylon Zoning Board of Appeals. The following is the procedure that will be followed tonight. The matters will be called in the order they appear on the calendar, with adjourned matters being called at the end of the regularly scheduled matters. Matters cannot be heard prior to their published scheduled time. When your matter is called, please submit the affidavit of posting to the secretary and proceed to the podium and give your name and address. The chairperson will then swear you in and read into the record information we have from your application, comments from various town departments, and any correspondence received on your application. The chairperson will then ask you to make whatever presentation you wish to make to the board. After you have made your presentation, the board will ask whatever questions the board deems appropriate, and then we will ask for comments from the public. If you wish to speak for or against an application, we ask that you wait until you're acknowledged, come forward, give us your name and address, tell us where your property is in relation to the property that's in question tonight, and then please direct your comments to the board, not the applicant or the applicant's representative. We have to keep a record, and we cannot do that if there are people talking over each other or cross conversations. If someone has spoken for or against an application, and they have said exactly the same thing that you wish to say, it will have the same force and effect in the record if you give your name and address, are sworn in, and say that you join in those comments. If you have anything additional to say, please don't hesitate to do so, but keep in mind that you will be given only one opportunity to speak. After the public has spoken, the board may ask the applicant to come back to answer any questions that may have come up as a result of the public comments, or for the applicant to summarize. When the applicant comes back to answer any additional questions, if that happens, that does not start a second round of public comments. Once the matter has been heard, various things may occur. The board may decide the application immediately. It may reserve decision. If the board reserves decision, that does not mean the matter is approved or denied. It just means that the board needs more time to decide, may want to go out and look at the site again, or might want to review the documents and testimony further before making a decision. In either event, the applicant will receive the board's decision in writing shortly after the board makes its decision. If the application is approved, that does not mean that you can then go ahead and start construction or whatever it is that you requested from the board. You will have to wait for the building permit to be obtained from the building department before your go-ahead. On some occasions, the matter may be continued for another night. If it is continued, in most cases it will be for the submission of documents, a new survey, new plans, or something of that nature. If that's the case, no one needs to come back on the new date. The documents will be submitted and no further testimony will be taken. On rare occasions, a matter may be continued for future testimony. If that's the case, then people would have to come back to testify. If matters are adjourned at an open meeting on the scheduled date of hearing, no further notice need be given unless specifically required by the board on the date the adjournment is granted. 3 rules that may affect your ability to proceed tonight. 1. If the sign was not posted for 10 days, we cannot hold the hearing tonight. 2. If you commence this proceeding while you own the property, but no longer own the property, and you are here now to continue with the application, you will need either the written consent of the new owner or the new owner to be present for the hearing. This situation could come about if you sold your house or building, money was held in escrow at closing for a certificate of occupancy or permit, and you're here tonight to clear that up. Lastly, if your application is a commercial application and it's other than a renewal and there is more than one tenant in the building, then you need your landlord to be here. Is there any applicant that has any difficulty with those situations and would need an adjournment tonight?
Is there anyone who would need an adjournment? Please rise and join the board in Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First application tonight is application 2671 of Aman Khan, property located in West Babylon. Name and address for the record, please.
Good evening. My name is Kyle McKenna. I'm an architect with Campbell Cassetta Architects at 1 John Street in Babylon.
Good. And do you affirm to tell the truth?
I do.
For the record, we have a planning division memo dated May 20th, 2026. A environmental control memo dated May 28th, 2026. If approved, this application will not result in significant impact. We have a survey by Peter J. Barbizon dated 11/4/25. Plans by Campbell and Cassetta Architects dated 1/9/2026. 4 photographs, and we also have the affidavit of posting. What would you like to tell us about the application?
So the clients are looking to do an addition to the second floor, which will be used for their family. We understand that they do need to pursue an accessory apartment permit, but their plan for this project is to have their parents on the first floor of the property, and then they will be living on the second floor. So to do that, they're looking to expand with their growing family, 3 daughters, and an ever-growing number of stuffed animals that they're hosting in their house. But what they're looking for right now is just a little more space in this house.
Okay, thank you. Turn the hearing over to Mr. Shepherd.
How are you?
Good, how are you?
Good. So we're gonna have, there's gonna be a kitchen upstairs and a kitchen downstairs.
Correct.
And you agree to apply for and maintain an accessory apartment permit.
Correct.
Okay. The only issue I'm gonna have with this is you need to have some kind of internal access.
That should be no problem. We spoke with the clients beforehand, and looking at the first floor near the new stairs that will be going up, in between the laundry room and kind of the base of those stairs, they would be open to adding a door in that laundry room.
Okay, well, you're gonna need to submit plans
Okay,
accordingly, okay? And then we can move on it.
okay,
And also, the front porch, you agree not to further enclose it?
agreed.
Okay, so that's the 3 conditions. The only other thing is the fence you got there along, I think it's 6th Street.
Correct.
You're not gonna go any further with it, right? We'll leave it where it is because you're not allowed to have it in the first place that height. But you're 40 or 50 feet off the corner, so.
So we were looking to move it to 32 feet from the 12th Avenue
I
corner.
drove by it yesterday. Whatever it is, whatever you have right now, I'm fine with,
Okay,
all right? We're not coming any,
You're gonna make,
you're gonna bring it closer?
closer to 12th, so that way it encloses the new stairs on the north side.
Then you're obstructing traffic,
Okay,
all right? So let's just leave it where it is.
sure.
I have no further questions, Mr. Chairman.
any other questions from the board? Would anyone like to be heard on this application? For the record, there are none.
No, it would still be in the front yard, but the revised plan should show the fence in the current location
Okay,
with the internal access.
okay,
All right,
All right?
all right. So we're going to close the hearing, reserve decision. We'll keep the record open for the new plans that we just talked about, and then we can move on the application.
okay.
All right?
If I may just make one more comment about the area, looking at the letter we received from the planning division, there was a comment in there about the 39%, us being over.
Yeah,
So that calculation, that includes our paving area as well as the building. So looking at the actual building, we're under 24%. So that 39% number seems a little large in comparison to the 30%, but it's largely the existing paving on the property.
well, everything gets taken into consideration. It's not just the house.
Of course.
Okay. So what are you saying there? That
It was an item in the letter that we received from the planning department, and noting that may want to be a discussion.
Just wanted you to describe why it was needed, which you've done.
Excuse me?
We wanted you to describe why it was needed, which you apparently have done.
Okay, fantastic.
Yeah, okay. All right, so we'll close the hearing. Thanks for coming down.
Thank
As
you.
soon as you get the new plans into us, we'll take a look, okay? Thank you. Okay, the next applications, that's 4 applications, are all ZBA 2675, 76, 77, and 78. They're all located in Copiague.
Good evening, Mr. Chairman, members of the board. For the record, Nicole Blanda. I'm an attorney at Bizzell Blanda Visconti with offices at 535 Broad Hollow Road in Melville.
Okay, for the record, we have a planning division memo on application 2675 dated May 20th, 26. We also have a planning memo on 2676 dated May 20th, 26. On 2677 dated May 20th, 2026. And the last one is on 2678, also dated May 20th, 2026. We also have environmental control memo dated May 28th, 2026, which is the same on all the applications. Just the only comment I see here, a basement is proposed on the site, and based on the test boards provided, the applicant basement at this location will not be problematic. Also, on all of the applications, we have Suffolk County Planning, dated May 11th, 26, decision of local determination. Take no position for or against. A survey by Pinnacle Land Surveying, dated April 17th, 2026. Plans by Spaces Architecture, Surveys Architecture, dated March 4th, 2026. 4 photographs, and we do have the affidavit of posting on all the applications. Okay, what would you like to tell us about the applications?
I'm here tonight on behalf of the property owner, Great Neck Road Holdings LLC, seeking variances for 4 out of the 6 parcels. So I'm going to talk about it in its totality. I think it makes the most sense. Thank you. The property's on the west side of Great Neck Road, 482 feet south of Copiague Place in Copiague. It is comprised of 7 tax lots currently. It has 1.5 acres. It's zone residence C. The reason why it's currently configured the way you see it on the aerial or on the tax map is because back in 2008, a different developer was going through a subdivision process. They did get a planning board approval, but they didn't make it to ZBA, and then for financial reasons, they dropped the project. So this is actually a better reiteration of this subdivision because now the cul-de-sac will be built to town specifications and dedicated to the town as a public road. And we've created lots that are probably better suited size-wise and things like that. If you look at the tax map versus this layout, we believe this layout is actually better. So we're seeking to do a 6-lot subdivision. Each lot will actually exceed the lot area requirements in Residence C. And I will take you through the 4 lots that require variances. So Lot 1 does not require variances. Lot 2 has a lot area of 7,694 square feet, so it exceeds the lot area requirement. We are seeking 2 variances. One is to diminish the front yard setback from 30 feet to 23 feet 10 inches, and diminish the rear yard setback from 30 feet to 18 feet 10 inches. The reason for this, if you look at parcel 2, you could see that the house is longer than it is deep, and it's a result of having a diminished depth because of the cul-de-sac. So for this road to meet town specs, the cul-de-sac itself, the radius and the curvature had to be widened, and so it does kind of cut into some of the parcels, creating a shorter depth. So we minimize the variances that we need. So for this parcel, we only need those 2 setback variances. We meet all other setback requirements, and we exceed lot area, and we meet building area as well. For this home, the first floor would have a foyer, family room, living room, dining room, kitchen, half bath on the first floor, internal garage, and then on the second floor, 4 bedrooms, 2 full baths, and a laundry area. This will have an unfinished basement for storage with an egress window well, so no outside basement entrance. For Lot 3, We're seeking to diminish the rear yard setback from 30 feet to 27 feet. It's solely at the egress window well. The rest of the home will be within the 30-foot rear yard setback requirement. We are also seeking to diminish the width at street line from 75 feet to 45.72. Now, this lot exceeds lot area at 9,491 square feet. And the street width is, again, due to the curvature of the cul-de-sac, and it does immediately widen as you head westward or to the rear of the property. So it's only for a very, finite period where it's 45.72. And visually from the street, as the planning department also pointed out in their memo, it doesn't appear to be less than 50 feet. So it's a pie shape, it's irregular in shape, but it's a pie shape, and again, it is oversized for residency. This home will also have 4 bedrooms, 2.5 baths, with a family room, living room, dining room, kitchen, and an unfinished basement and a garage. Lot 4 is one of the largest parcels. It has 10,309 square feet. This is another pie-shaped lot because of the cul-de-sac, so we are looking for a similar street width variance from 75 feet to 44.36. But again, as you can see, the lot widens immediately as you head to the rear of the house. We are also seeking a rear yard setback for the window well from 30 feet to 27 feet 3 inches, and the rest of the dwelling will be within the 30-foot or greater rear yard setback. This is also a 4-bedroom, 2.5 bath house with an internal garage, unfinished basement, and similar amenities. Lot 5, we are seeking to diminish the front yard setback from 30 feet to 23 feet 3 inches, and the rear yard setback from 30 feet to 21 feet 2 inches. And again, this is because of the diminished depth due to the cul-de-sac, the curvature, the radius. And on this lot, we have 8,873 square feet. So again, we exceed lot area. We minimize the variances that we're requesting. We're only requesting front and rear yard on this parcel. We're not requesting building area variances on any of the parcels. And so this would also be a house with 4 bedrooms, 2.5 baths, internal garage, unfinished basement. Each house will be different. There'll be 3 different styles. There'll be some mirroring going on, but there'll be different finishes for each house, and there'll also be different style roof lines. So, perfect. So if you look at the elevations, you can see that not only is there different maybe wainscoting or stone veneers, but there's also different ridge lines and things like that, different colors. So while the style of home may look mirrored, the finishings will be completely different, and so it'll give it, a pretty aesthetic as you go around the cul-de-sac. The entire site will have new 5-foot ADA-compliant sidewalks, new curbing along Great Neck Road. There'll be a 5-foot buffer along the perimeter of the property with arborvitaes and cypresses. All utilities will be underground. In the surrounding area, there was a 6-lot subdivision to the north that was approved relatively recently off of Great Neck Road. That was also a cul-de-sac. To the south, a few lots down, is Anthony Court, which is a 10-lot subdivision that was approved back in the late 90s. There's various size lots in this area with various depth, but again, given that this was subdivided previously, it was never fully completed, but we do feel that this is a better layout than the current tax map, and the owner does agree to all covenants, single-family, owner-occupied, no accessory apartments. If the board has any questions, I'm happy to answer.
Thank you. Turn the hearing over to Mr. Dellavecchio.
Good evening, how are you?
Good, how are you?
Good. You answered a lot of my questions. At the rear of all the properties, that's where you're going to be placing the arborvitaes?
Yes, so along the perimeter of so north,
Where all those circles are?
yes.
Okay. Is there any way to make them, like especially lots 4 and 3, a little bit smaller so there isn't as much of a rear yard setback? Because as of now, there's no patio, but let's just say in the future, the new homeowner wants to put a patio, they're going to be right up against their neighbor to the west.
Well, if we push the homes forward, we would need a front yard setback variance for those lots.
Yep.
And if we even if we made them slightly, we're meeting the side yard setbacks, so, and we're not asking for a building area variance. The only portion that needs the rear yard setback is that little window well. You know, that's on the southwest corner of the house on Lot 3.
Yep.
And the northwest corner of the house on Lot 4 is what's generating that rear yard setback.
The rest of it,
So presumably Lot 4, if someone wanted a patio, there is room next to the garage area or in that corner area. I guess you would say that's the southwest corner.
I guess where the steps lead out.
Right, there is room there. If you see there's a dotted line, oh, it's not on this plan, but there's a building envelope line that shows where the 30 feet, where the 30-foot setback is. So there is room on that lot for a patio that would not impinge on the setback over there.
Okay. It would definitely look a lot better than what's there currently, so.
It's all wooded, yeah. Overgrown, yep.
I got no further questions, Mr. Chairman.
Just the one thing, the applicant should confirm that the requested variance does not affect any changes made by the planning board.
Yes, so the last request from the planning department was for us to submit signed and sealed surveys, which I uploaded. There was nothing else, so yes, the variances will not be affected.
All right, any other questions from the board? Would anyone like to be heard on this application? For the record, there are none.
Do them all together? Do them all together? Mr. Chairman, I'd like to make a motion to approve applications 26-75, 76, 77, and 78 with all the covenants and restrictions on the planning memos.
Second.
All in favor? Aye. Good luck.
Thank you, have a good night.
Have a good night.
Next application is application 2672 of Best Way Auto Collision, property located in Deer Park.
Good evening, Abraham Duman.
Okay, and address?
725 Acorn Street, Deer Park, New York, 11729.
Okay, and do you affirm to tell the truth?
Yes, I am.
For the record, we have a planning division memo dated May 22nd, 2026, environmental control memo dated May 28th, 2026. You have spray booths here?
Yes, we do.
Okay, so they meet, they were in compliance
Yes.
with all the regulations?
No, they're all compliant.
Okay. Suffolk County Planning Memo dated May 11, 2026, decision of local determination, take no position for or against. We have a survey by Paul Borowski dated August 3rd, 2021, plans by Design Land Surveying dated October 31st, 2007, 3 photographs, and we have the affidavit of posting. Okay, what would you like to tell us about the application?
I've been there, the location 2003. I just want to renew another 3 years, or if not 5 years. That'd be better.
Okay, turn the hearing over to Mr. Montiglio.
Good evening, how are you? Has any changes been done since the last board meeting?
Building wise, no, just the color.
No, the whole business model. Did you change
No, same.
anything?
Same.
Same thing there. Can you be a little more timely with the renewals next time?
Yeah, because this one is, you guys went into what they call the name is on digital or something, so that's why it takes a lot of time in going back and forth. I couldn't even do it. I have to hire someone to do it. Because it was different this year. I'm sure next year is going to be very
Portal.
easy.
You have to upload it into the portal.
Listen,
Yeah, I know.
I'm not that genius.
I get it.
All right, well, they're waiting for a fire marshal. That wasn't received. The fire marshal report yet wasn't received yet.
No, they did not show up this time.
You had the fire marshal there or no?
No.
No, you have to have fire marshal. You have to have the fire marshal.
Yeah, I know. Normally they come, but they didn't show up. I don't know. why.
Yeah, well, you're gonna have to get in touch with them and make sure that they come before we can move the application.
That's no problem.
No further questions, Chairman.
Any other questions from the board? Would anyone like to be heard on this application? For the record, there are none. Okay, we're going to close the hearing, reserve decision. We'll keep the record open for fire marshal's report. Next application is application 2673 of Best Way Auto Collision, property located also in Deer Park. Name and address for the record one more time.
Ibrahim Duman, 725 Acorn Street, Deer Park, New York, 11729.
Okay, and you affirm to tell the truth?
Yes, I am.
For the record, we have a planning division memo dated May 20th, 2026, environmental control memo dated May 28th, 2026, Suffolk County Planning dated May 11th, 2026, decision of local determination, take no position for or against. This has a survey by Gerald O'Buckley dated June 6, 2024. The plans, the name was not legible, but the date on the plans was 12/1/2017. 3 photographs, and we have the affidavit of posting. What would you like to tell us about this application?
We run that building since 2014. We opened up 2018 on the business. We get all paperwork from you guys, and we're running exactly the same way. Collision and towing and repair cars. We want to continue doing it, and we're going to extend another 3 years or 5 years. That'd be better.
Okay.
That's
Turn the hearing over to Mr. Montiglio.
All right, basically same question. Had any changes been done?
no.
Okay, same thing. You see this in excessive outdoor storage. There's a lot of cars and boats. It needs to be minimized.
Boat. There's no boat there.
Well, other materials, that on an area view, there was boats, yeah.
There's a little
I used to be.
Okay.
Yeah.
What do you have back there now?
Oh, the regular cars. Waiting to repair.
You got to get rid of some of them. There's just too many back there. It doesn't have it on the site plan that way.
I will.
So you see where the arrow is? There's a boat right there.
Oh, jet ski.
Oh, jet ski?
Jet ski.
Oh, jet ski.
Okay.
Okay. Same.
Same thing though.
Man,
You still
It's
gotta.
in the water.
I'm sorry.
Again, we need to have more timely manner on the renewal
No problem.
and waiting for the fire marshal on this as well.
Yeah, they didn't show up. But
Okay.
We'll definitely call them tomorrow.
All right. No further questions, Mr. Chairman.
Any other questions from the board?
Just one. If we were to approve it, you agree to the previously imposed covenants and restrictions for public garage?
Yes, I am. 100%.
Thank you.
Would anyone like to be heard on this application? For the record, there are none. Yeah, we need fire marshal. So we're going to close the hearing, reserve decision, keep the record open for fire marshal's report. Next application, excuse me. Next application is application 2674, again by Best Way Auto. This property is located in Wyandanch. Name and address for the record.
Ibrahim Duman, 725 Acorn Street, Deer Park, New York, 11729.
And do you affirm to tell the truth?
Yes, I am.
For the record, we have a planning division memo dated May 22nd, 2026. This one has a valid fire permit. Environmental control memo dated May 28th, 2026. Survey by Rampa Land dated August 17th, 2023. Plans by Mohammed Surveyors Ahead, PE, dated October 29th, 2024. 4 photographs, and we have the affidavit of posting. Okay, would you like to tell us about this application?
This location, we're supposed to do it, running auto body shops, and then what happened is we were a problem with the manager running the other shops. We have to take him up, so I have to rent that place. I rent it to the guy who's supposed to stay with the town of Babylon rules and regulation, but he didn't. He didn't, I know. And then what it is we already have served the paperwork. We threw them out, so already served by mail, served by Allstate, what they call, they do paperwork. They already served them, so we're waiting to court date. to
So
come.
is he still there? He's still
He says,
operating?
unfortunately, he's there, so I can just get him out of there, you know?
Yeah, all right, so you're
Unfortunately.
looking to get him out of there, and then
Oh,
you're
yeah.
gonna clean this
Yeah, we
place
already
up?
served them the regular mail. We already served them the serve company, Allstate and Deer Park, what they call name. They already served them, so it's gonna come out because we don't run business like this.
Okay, so also, there was like all grass around the front and the sides and stuff? What happened to the grass?
I gotta do is, I'm sorry, I cut you off. I gotta do is regular grass, it doesn't grow up, but too expensive. When this trouble came in, so we have to stop doing anything, so.
So, okay, so everything needs to be run. You need to get this guy out of here, and then
clean
you're
up.
gonna fix everything up?
Yep, 100%.
And clean it up? So at this point, then, we can't approve the application as is. I mean, you're gonna have to get him out of there.
Application, I don't wanna kill the application, move on,
All right,
completely.
so, all right, so do you have any idea how long it's gonna take you to get him out of there, or?
We have the serve paperwork, we have to serve the all states, so that 2 serve already been done, so it's gonna be what they call on name is, only the court date is gonna decide it's gonna come out, that's all. On the sheriff, so probably months, if not a little over months, that's it.
Yeah.
That's how it goes, I guess.
What do you want to do with this? You want to hold it? I mean, we're going to hold it, obviously, but... Okay. All right, so we're gonna hold the application, but you're gonna have to get back to this, like, when you get him out of there and stuff like that, so that we know what's going on. We'll hold the application, for a while until you can get that done, but once you do that, you got to get done with cleaning this place up and straightening everything out.
Yeah, 100%, but
All right.
meantime, I don't wanna leave the application
No, I
open,
understand, I understand. You want to keep it, you came in on a timely manner and so on and so forth, so you want to keep that going. I get it, but, obviously, and that it needs a lot of work, so.
Unfortunately, I have no luck on the tenant because I have another 154. I have the same problem. I have to sell the property. I bought this one. I fixed myself, but
The special exception is also to the tenant, so you can't rent it out under your special exception permit.
no, it's not. They're supposed to. He apply his paperwork. It's not. You're supposed to use on mine. He's supposed to apply his paperwork.
Right.
This place is 1960 auto body shop. It's not supposed to need a special permit. I don't know that.
You're the landlord, so whoever's going to rent the place going forward.
Yeah, they have
is
to apply the
going to need to
paperwork,
come
yeah.
in here and apply for a special exception permit.
As soon as I rent it, a month later, I figured that out. It's something is not going to work out. That's why we pushed everything, so take him out of there. But it was within in the month. I couldn't take it off within the month, but I passed the month, so I could not take him out of there.
Yeah.
So I'm going to take him out. There's no doubt about it.
So just to clarify also, the part that you have cement where it's supposed to be grass, you're gonna put grass again, correct? Okay.
No concrete. It's already grass, so.
It looks like cement, concrete.
No, it's not
There was an
cement. No,
inspection done.
That's the dirt. That's not cement.
That's not dirt, that's concrete.
That's not concrete.
That's dirt?
That's dirt there?
RCA?
Yeah, RCA mixed dirt, something. I don't know exactly what they call, but something.
It should still be grass though. You have it.
Oh,
on-
yeah, 100%. That's no doubt about it. Yeah, definitely.
You know what, there was a visual inspection on May 22nd, so they noted that it was concrete, so.
No, concrete only driveway. If you see the concrete, different driveway on the front, like concrete.
It's hard to tell from the picture, but.
Yeah, I understand.
But just, you understand though.
Listen,
Okay, thank you.
I've been working with you guys like long enough. Yeah.
No problem.
I'm
Any
not
other
gonna do everything picture. I'm not gonna do wrong something and come back here.
Any other questions from the board? Would anyone like to be heard on this application? For the record, there are none. We're going to close the hearing. We're going to reserve decision.
Please.
Okay? You'll get back to us when you have some movement over there?
I'm gonna keep you. I talked to my lawyer. I tried to call my lawyer today what we have, but he didn't get back to me. I don't know what is exactly going on.
Okay.
So
All right.
I will definitely get and then let you guys know what's going on.
Thank you.
Thank you very much, guys. Thank you.
Okay, thank you. Next application, application is 2638 of Andrew Meyerowitz, property located in Copic. Name and address for the record.
Keith Archer, Harris Bloom and Archer, 445 Broad Hollow Road, Melville, New York.
Okay,
Good evening.
how are you? For the record, we have a planning division memo dated April 2nd, 2026. Environmental control memo dated April 6th, 2026. If approved, this application will not result in significant impact. We have a survey by Scalise Land Surveying dated December 7th, 2023. We also have plans by Scalise Surveying dated December 7th, 2023. 5 photographs, and we have the affidavit of posting. Okay.
Number 5.
Number 5.
5, 6.
Correspondence. So we have correspondence from, okay, so it's number 5, number 6, number 7, that's it. 5, 6, and 7, there's correspondence.
Number 9. Number
And
9.
number 9?
Yeah.
And number 9, okay. Oh, yeah, there's a big packet in here on number 9. Okay. Okay, what would you like to tell us about the application?
Okay? Oh, okay. Thank you. I'm sorry. So, good evening again, Mr. Chairman and members of the board. So we're representing the applicants in this request for a minor side yard setback variance for a garage that's has been constructed on the north side of the Meyerowitz's property in accordance with a duly issued building permit. Joining me tonight in offering testimony is Tom Dixon, who is a partner and professional engineer with Nelson and Pope, and Michael Lynch, who is a licensed appraiser and real estate expert. So as board members are no doubt aware, this property has a bit of a history before this board. After obtaining required variances and building permits for significant improvements to their backyard, including reconstruction of an existing garage along the north property line, it was discovered upon review of a final as-built survey that there had been a mismeasurement of the north side property line, which resulted in a side yard setback of 2.2 feet. I believe your sheet indicates it's 2.1. I think our survey indicated 2.2, but I'm not going to quibble. And that's as opposed to the 3 feet that's required for a single separate lot, which this has been determined to be. So that measurement error requires a variance of 0.8 of a foot, or about 10 inches. So a public hearing on the applicant's request for a side yard variance, as well as other backyard variances, I'll call them, was held on May 9th, 2025. In August of that year, the board declined to grant the side yard variance while approving all other requested variances. So some additional background is needed. At the May 9th, 2025 public hearing, the owners of the residential property to the north, Stephen and Diane Hawkhurst, appeared in opposition to the requested variance. Basically, they were stating that rainwater from the Meyerowitz's property and from the garage were coming off and onto the Hawkhurst property, flowing over the Hawkhurst property and resulting in flooding of the Hawkhurst basement. Now, there had been ongoing disputes between the Meyerowitzes and the Hawkhursts over a period of time, and that culminated in a civil action being filed by Mr. and Mrs. Meyerowitz. However, I'm pleased to report that a settlement agreement was fairly quickly reached by the parties and has been submitted for the record. As far as we know, no further controversy exists between the two neighbors, and the Hawkhursts have agreed not to appear at this hearing. Before the settlement was reached, in anticipation of this new hearing, the Meyeritzes commissioned a report by Nelson and Pope, which has been submitted for the record, by the way. This report analyzed groundwater over a period of time and surface water flow during a period of rain. This analysis was done to determine if stormwater from the Meyeritzes property was flowing onto the neighboring Horkhurst property, where they have indicated that they have had flooding in the basement. So Tom Dixon, who is a partner at Nelson and Pope, is here to describe the findings. But in short, Nelson and Pope found that the surface water was not migrating to the Horkhurst property, and that the leaders and gutters on the Meyeritzes' newly reconstructed garage were effective in capturing rainwater and directing that water onto the middle of the Meyeritzes' property. The report concluded that stormwater from the Meyeritzes' property did not impact the adjacent Horkhurst property. To support the conclusion that granting the requested 10-inch variance will not have an adverse impact on the neighborhood, we will present the testimony of Michael Lynch, a licensed real estate appraiser and real estate expert who's been accepted by this board before as an expert, who will offer testimony that approving the requested variance will not have a negative impact on the neighboring properties. So with this said, I would request that the board permit Tom Dixon to offer testimony.
Yeah, we accept.
Thanks.
Name and address for the record, please.
Good evening, Mr. Chairman, members of the zoning board. For the record, my name is Tom Dixon. I'm a partner and professional engineer with the firm Nelson and Pope. Office is located at 70 Maxis Road in Melville.
I do affirm to tell the truth.
I do.
Okay, what would you like to tell us?
Yes, my firm was retained by the property owners to prepare a site drainage investigation and to determine whether or not the stormwater runoff from the newly constructed garage was impacting the neighbor to the north, the property to the north. We performed a site visit on December 2nd, 2025 during a rainfall event. The garage has a gable roof that has a pitch to the north and to the south. There's gutters located on both sides, on the north side and the south side. They're both fully operational. They pitch to the east side of the garage, and there's leaders located on the northeast and southeast corners of the garage. At grade, there are extensions, leader extensions, directing the stormwater to the east and central portion of that rear property line. During our observations, we did not make any observations of stormwater along the north property line being directed in a northerly direction or any ponding in that area. The garage is pitched to the west in front of the garage towards Baylon Avenue. The front portion of the driveway is pitched to the north, but there's a grass swale along the northerly side of that driveway that takes it out to the to Baylon Avenue. So again, during our observations, we did not make any observations of stormwater being directed towards the house on 135 Baylon Avenue. And it's my professional opinion that that the runoff from the garage is being contained and is not impacting the property to the north. Just of note, the residents at 135 Baylon Avenue, there's no gutters or leaders on that residence, and when you have that situation, the water will tend to collect and pool around a foundation. If there's cracks or voids in a foundation, this can be cause of basement water issues. Also, as part of our investigation, we did install a groundwater monitoring well on the subject property monitored for a period of 30 days. Groundwater is only about 4 feet down in this area, so there is definitely a high water table. And again, that also is a a potential cause for water problems in the basement of 135 Bay Lawn. So that concludes my presentation. Be happy to answer any questions the board may have.
Any questions from the board? Okay.
Yeah, two of them.
Can you answer this? We're asking about behind the garage, there's two structures, the shed and I guess two sheds? Is that two sheds?
Yeah, there is a shed yes, you're seeing the shed directly behind the garage. Further towards the river is another shed. I believe there might be the pool equipment inside that. Yes, there's pool equipment inside the other structure further towards the river, yes.
Okay. Thank you.
Okay.
Thanks. So, did you have any questions, Mr. Chairman?
What'd you say?
Those are all subject to the board's prior hearing.
Yeah, okay.
Okay. So we're increasing the number of accessory buildings then, from one to two? From
The-
one to
This was the previously approved one.
That one, that's what was,
We approved 1, 3, and 4,
okay.
denied number 2.
We designed number two, okay, okay. Okay,
Okay, great, thank you. So, with the board's permission, Mike Lynch, I'm the applicant's real estate expert, will offer some relatively brief testimony. The board.
Okay. Name and address for the record.
Good evening, Mr. Chairman, members of the board. It's Michael Lynch, business address 15 Dewey Street, Huntington, New York. I have been recognized in the past as an expert here. I have a copy of my CV if...
No, you've been here before. We
Okay,
know that,
thank you.
right? Just do you affirm and tell the truth?
Yes. Before I begin, I have some exhibits that I prepared, with the exception of a survey. First exhibit is a copy of a historical GIS aerial view from 1947, and you can see the shadow of what appears to be the existing...
Stay by the microphone.
Oh, I'm sorry.
please.
This exhibit is from Suffolk County GIS, and it's a 1947 aerial. And in this aerial, you can see the shadow of the original garage that was replaced roughly in kind by the applicants. And I'd like to submit this
What are
as
you
an exhibit.
submitting? That that was approved at that time, or you're submitting it?
No, I'm just submitting it as evidence that the prior existing condition has stood for some 80 years or so at the site with the same setback. So I'd like to submit this. I have several copies.
Yeah, that's fine. Thanks.
And I have copies of a survey from 2007 of that noted prior garage, again, that stood at the same approximate footprint and setback of 2.2 feet off of the north boundary line. This, again, is a 2007 survey of the premises.
I'm sorry to interrupt.
Yes.
You said this is the aerial view? I mean,
That's an aerial, yes, aerial photograph from Suffolk County GIS.
okay. I'm going to be honest, I can hardly see anything.
That was the technology back. The lot lines are somewhat skewed.
But you're trying to use this to prove the fact that the garage was there prior?
That there was a near identical garage in terms of its footprint in that placement.
Okay, I'll be honest with you, I don't think we can accept that as proof of that.
Okay.
I mean,
I also have the survey from 2007, from that prior survey. Yes, that was. And lastly, I have, I was at the site this past Tuesday, and I have copies of photographs that I took at that time, as well as a Bing map aerial, which is very similar to what you have on the screen behind you. So good evening again. My name is Michael Lynch. I'm here to talk about the variance for the side yard of the new garage that was built a couple of years back. Again, largely in the same footprint of what stood there apparently for some 80-plus years. A similar two-car garage. And in that one exhibit, you can see also as well in the aerial behind you, this Bing map that I show on page 7 of my photographs. When this Bing map aerial was taken, you can see the footprint of the new foundation. And this exhibit is really to show, as in terms of character, that it's not a situation that's out of character with the area, especially with respect to the house immediately to the north, which has a garage that appears to have a very similar offset to the north boundary line. So, during my investigation of the property has been upgraded significantly in the past few years with a new in-ground pool. The grounds have been redone. There's new landscaping. The sheds were approved during the last application in 2024. The only thing that was denied, of course, was the setback for the new garage that was built, again, largely in the place of the original similar garage that had stood, from all indications, at least from 1947. At this point, I'd just like to go through the standards under 267B. With respect to the 5 standards, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties should the granting of the area variances take place. Again, this is a 0.8-foot or 10-inch variance from the 3-foot requirement. It's a condition that has been in place from all indications for some 80 years or so, if you consider the prior garage that stood in the near identical footprint of this new garage that was built a couple of years ago. Therefore, in terms of a detriment or a changing of the character of the area, again, it's a situation, a condition that has existed for many years. Moreover, the house immediately to the north at 135 Baylon Avenue, again, that has a garage, and you can see in that aerial, as well as the exhibit that I prepared, that garage has what appears to be a very similar offset or setback to the north boundary line. So in terms of area character and the pattern of development up and down Baylon Avenue, I don't see the approval of this 0.8-foot setback variance causing any deleterious impact to neighborhood character or certainly property values. And again, the property has been significantly upgraded. The Meyerowitzes, again, added a new pool, new sheds, new landscaping, et cetera. So in terms of their property values have certainly improved by these new improvements that were put in place the last few years. So that's only enhanced the median property values in the immediate area. So from that standpoint, there will be no detriment. Whether this relief can be achieved by some method that's feasible to the applicant to pursue, based on, from what I understand, the contractors that were hired to rectify the situation, the estimates came in roughly $35,000 to $40,000 according to Mr. Archer and the applicants. So it would just be prohibitive based on, again, to move this structure 0.8 feet and to rebuild it, again, when there is no impact to the neighborhood character or to the pattern of development up and down Baylon Avenue. Whether it's a substantial request, well, It's 0.8 feet or 10 inches. On its face, it would appear substantial. It's a 26% request, which would appear, again, mathematically be significant, but reality and in context with, again, what stood there for some 80 years, as well as other properties up and down Baylon Avenue, including the abutting neighbor to the north at 135 Baylon Avenue, who appears, again, to have a garage with a very similar type offset or setback to the north property line. So I would contend that the requested area variance is not substantial.
Do you know if that was approved by this board? Do you have any?
No, again, it dates back, I believe, based on aerial photography, to a similar time as the Meyerowitz's property.
Okay, thank you.
Mr. Dixon, the professional engineer, touched on whether there's any impact to the physical or environmental conditions in the neighborhood based on this newly constructed garage. And again, he testified that there is no impact to the environmental or physical conditions in the immediate area. And lastly, under 267B, whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the ZBA, but shall not necessarily prohibit the granting of the area variance. Again, obviously it was self-created. The old garage was torn down and likely, primarily in kind, a new garage was put up again in largely the same footprint with the same setback. So it was self-created, but again, it's not a condition that will impact the community. And it effectively, again, has been a condition that's been in place for decades. So this standard in and of itself should not preclude the granting of the variance sought by virtue of the positive foregoing factors in support of the zoning relief. And at this point, I can answer any questions if the board may have any.
Any questions from the board? Okay, thank you very much, appreciate it.
Thank you.
Good job.
You have
So-
anything else for us, or can I?
What?
Do you have anything else for us, or
No,
can I ask you a question?
very, very quickly.
Okay.
And I think that Mike may have submitted it, but there was a survey from, did you submit this one, Mike? 2007? 2007. Okay, so what's compelling about this survey is that it shows the setback of the garage on that property, and right on the survey, it says 2.2 feet. So I think what we're getting at is that this really isn't a change. It was a mistake. It was supposed to be 3 feet. Somebody made a mistake, but the setback seems to be consistent with the prior setback. So as Mike Lynch had indicated, it doesn't have any impact, on property values or the neighborhood. Also, let me submit for the record, if I could, this is a letter of support from several of the
Okay.
residents along Baylon.
Yeah.
So anyway, Mr. Chairman, this concludes our presentation, unless board members have any question. But I believe that the testimony tonight provides the board with the legal basis to approve the requested variance. And we need to bear in mind that this was a mistake that was done. It was a mismeasurement. It wasn't caught until the as-built survey was done. So it was not intentional, very unintentional, actually. So with that, we would ask that the board, approve the requested relief.
Okay, so let me, okay, maybe you can just go into, because it is part of the correspondence, the settlement agreement, exactly how does that affect any of this?
Okay, so there has been, it's a good question. There was tension between the Meyerowitzes.
We know that, okay.
Okay, you know that. And so eventually there was a civil action brought to kind of just, we got to stop this. So an action was started. the Hawkhursts were represented by very competent counsel, right? The Meyerowitzes were represented not by me, but by my firm. And we quickly arrived at a settlement agreement that also has a boundary line agreement attached to it. So we resolved any issues with respect to the fence, right? And we resolved presumably any issues with respect to any tensions that exist between the parties.
Okay, that's what that agreement is.
And they're all submitted for the record.
Yeah, no, that's why I'm asking about it, because I just wanted you to sum it up for me in layman's language.
In layman's language, it's been settled.
Okay.
It's been settled.
Okay, that's a fair answer. I'll turn the hearing over to Mr. Dellavecchia.
I guess I'll ask again, but I'm sure I asked it back in 2024. When it was being demolitioned and then reconstructed, why wasn't it put back to the conforming location or to a conforming location?
There was a mismeasurement. I was not involved at that point, but whoever measured from the wrong, they measured from a fence, which wasn't the property line. It was a mistake, Mr. Dellavecchia.
Yeah, because I can see the fence from the aerial that goes.
Yeah, it zigs, and they shouldn't have measured from that. There was never any intent, to do anything but be at the 3-foot setback.
Okay, and then I got another question about these 4 violations that have went on. I understand that they have been solved, but what's going on with that?
The violations?
Yes, the noise
They've all been
complaints.
solved. They've all been resolved. You mean the violations that were issued by the town?
Yep, I understand the fence one. I know that they were all resolved, but the noise complaint, and then I guess 2 other ones were.
They're all resolved.
Resolved.
They're all resolved through the town attorney's office.
So my point with that is just not being a good neighbor. So I understand that it's a single and separate, and that it does look like, even though it's only, let's just say 10 inches, still it's a 20 by 18 garage. So it looks massive. And then we also agreed to allow 2 accessory buildings and 2 sheds.
Correct.
So there's a lot going on at this house.
There is. Correct.
And back in 2024, we referred this 2.1 or 2.2 to council, and 2 years later, we're back here and nothing has been done about it.
Well, the only thing I can say to you is that it was never intended that this happened. Neither the mistake in the measurement or the tension between the 2 adjoining property owners. But that's basically been resolved with this settlement agreement. I hate to say this, but sometimes, people have to pay some money to hire lawyers in order to get, peace. And I think that's what happened here.
Yeah, my only issue with this is, now it sets a precedent along Bay Lawn that people could construct 20 by 18 sheds 2 feet from the property line, which is what we don't want. We're coming asking for such variances of that magnitude.
Well, I think this situation is a little bit unique because of what was on there before. So, basically the same dimensions. In other words, if it wasn't for the setback issue, you and I wouldn't be speaking to each other.
But the fact that it was demolished entirely, leveled, it's not like they replaced just the shed and the foundation was still there and it went back onto the foundation. Let's just say the foundation was still there and they just removed the shed and replaced the shed there, and it's a completely different thing. They've completely demolished it, built a new foundation in the wrong location.
Yes.
I understand by mistake.
Yes, and as you know,
Yeah.
a building permit was issued, and it was built. I bet you and I think it had inspections. It was built in compliance with the building permit, except for this little darn setback issue, which wasn't the fault of the applicant.
Well, technically, yes, it was, but.
Why is it the fault of the applicant? The applicant didn't do the measurements.
No, but if I hire someone to do work in my house and they do it wrong, it's my fault, it's my house.
Oh, okay, if you want to put it that way, yes.
you
But
know?
in the actuality,
Yeah.
it was an error, an unintentional error
Yeah.
by either the architect or the contractor.
I agree.
And because of construction, it's hard to, you know this, because of construction, it's hard to tell what's going on.
Yep. No, I get that, totally.
But it was totally unintentional. I mean, it's not like he said, I'm going to do this, and then go to the zoning board and legalize it. Please believe me, that didn't happen here.
Got it.
Yeah, really? Yeah.
I got no further questions, Mr. Chairman.
It does, but it didn't happen here.
I have one, and it's just to clear it up in my head. So we've established that this thing was, or we think it was built in 1947. Do we know when it was demoed and when it was rebuilt? Was it continual? Was it like the next day, or was it months? Was it years apart? Do you understand? So it was put originally in 1947, your realtor says, right? So when did the demo, when was the original?
Most recently, when was it demoed?
Yes.
Right. So
Does anybody
Andrew?
know?
Yeah, so the pool, there was a lot done in the
So
back.
it wasn't vacant for like a year or
No.
two, and then it was like Wednesday we knocked it down, and then that Friday
Correct.
we started pouring concrete.
Correct.
It was 2023, they had to, we knocked it down.
you need to speak through your attorney or come up, please.
Christy Lowenstein Meyerowitz.
And do you affirm to tell the truth?
Yes.
Thank you.
It was 2023. We
Okay.
demolished it as part of the project with putting the pool in the backyard. The reason that we replaced it is because, quite frankly, it was rotting away and it needed to be replaced.
Right.
The foundation was cracked. So it was torn down and, they had to wait to clean it up, but the project was continuous.
Within a month?
Within
Okay.
the month, 6 weeks.
It wasn't empty for 2 years or anything?
Not at all.
That's all I wanted to establish. Thank you.
You're welcome.
Thank you. Are we done?
Any other questions from the board? Would anyone like to be heard on this application? For the record, there are none. We're going to close the hearing. We're going to reserve decision. You'll get the decision in the mail. Thank you.
Thank you. What? You got everything. I did. Good night.
Good night. Next application is application 2663, property located on 49 Eastern Avenue in Deer Park. Name and address for the record, please.
Hey, good evening. My name is Danny. I'm from Next Gen Expediting. The address in question is 49 Eastern Avenue in Deer Park.
What's your address?
My address is Next Gen Expediting, 3 Jacqueline Drive, and that's Manorville, New York.
Okay. And, yeah, spell
Excuse
your
me?
name for us?
My last name is Spees, Dan Spees.
And do you affirm to tell the truth?
I do.
What would you like to tell us about the application?
Sure.
Oh, I'm sorry. Getting ahead of myself. For the record, we have a planning division memo dated May 6, 2026. Environmental control memo dated May 7, 2026. If approved, this application will not result in significant impact. We have survey by Earl Lovell dated March 10, 2026. Plans by Keith Schulman dated February 2026. 4 photographs, and we have the affidavit posting? Yeah, okay. Just as you put an X there, I was like. Okay, okay,
Did you upload the affidavit of posting?
Yes.
okay. What would you like to tell us about the application?
Yeah, sure. This was originally a hearing on May 14th, 2026. We are seeking permission to diminish the rear yard setback from 40 feet to 25.3 feet. It was a humbling experience with the original sign that I had put together. So we adjourned it to today, May 28th. I went back and reestablished the sign on a better platform. to therefore, get the communication out to anybody that would have any concerns in addition to the mailers that went out.
Okay. So, what are you telling us about the application?
Oh, well, we're still seeking permission for the setback. It's currently zoned, it's supposed to be 40 feet. It's currently 25.3. And we'd like to seek relief.
Okay, that's it?
Yeah.
Thank you.
That's
I'll
it.
turn the hearing over to Mr. Montiglio.
How are you again? I saw the sign, much better work this time.
Okay, thank you.
Has any work been done since you purchased property?
To this house?
Yeah.
Yeah, so there's currently an application in for an accessory apartment. And the homeowner at this time, as I said, I represent him. And we're looking to be in compliance and bring everything up to where it needs to be.
I mean, the deck you're asking for, does anybody else in the neighborhood have that in the surrounding areas? I mean, the next door has it, but it's not quite as far.
Yeah, I mean, it's pretty consistent in the area. For this specific property, it allows, be able to exit the property, exit the house, and, be able to kind of move around the property.
All right, if this application was approved, would you follow the conditions, the second story of deck not being enclosed above or below?
Yes.
Accessory apartment must be maintained with additional unit within the dwelling?
Yes.
Okay. I have no further questions, Mr. Chairman.
Any other questions from the board? Would anyone like to be heard on this application? For the record, there are none. Good. Good.
Yeah. Mr. Chairman, I'd like to approve application 26-63 with the condition the second story rear deck not be enclosed above or below, and the accessory apartment must be maintained. Shall there be additional unit within the dwelling?
Second.
All in favor?
Aye.
Thank you.
Thank you. Appreciate it.
That concludes, right? That concludes, you didn't write it on the thing, you kill it. That concludes the streaming portion of the meeting.